Today we're going to talk about a guy, Marcus Taylor, who served 10 years for a sentence. The sentence was 15 years. He served 10, but the maximum penalty for the crime that the sentence was in relation to was 5 years. And we're going to look at his fight for post-conviction relief, and we're going to hear about how this lady, Attorney General, last name Fitch, can make some swaps there if you want, got mad that the Court of Appeals said, hey, that sentence is legally void. It's a hot mess. This all started this morning when I saw a quick little blurb, short little article here. And I'm going to make it readable. We're going to speed through it, but we're going to get to the governor's commutation, the executive order. We're going to look at the Court of Appeals opinion because it just keeps getting crazier. And instead of just making a quick post, I'm like, I have to go live. Like, I made it to page 3 of the Court of Appeals opinion, and I'm like, how does this happen? How is this okay? So good to see everybody. I'm glad you guys are all here to go through this with me. Shout out to the early birds, FFS, O'Bailey's, Martina Nem, M Loving Life, and Mr. Big Dog Fluff. I also dropped 5 gifted memberships in the chat for this 5-year discrepancy. I thought it was a good theme. So we've got Mississippi man ordered freed after serving more than 10 years of an illegal 15-year sentence. So, a man illegally sentenced to 15 years in prison for a crime that carries a maximum penalty of 5 years is set to walk free, but only after Mississippi Governor Tate Reeves granted him clemency on Wednesday. Now, Kat, why are you saying only after? Well, because this should really be open and shut, right? You find out that a sentence is legally void, fix the sentence. Oh, he already served the max time? His time is served? If we resentence him to 5 years, he's done, right? That's what you would think. Nope, there's a whole, hero story adventure. We've got to play, Mario 1, 2, and 3 to get to the finale and get this guy released from prison. This should be a 2-second story, but it's not. So let's see what happened. So the Mississippi Court of Appeals ruled in May. This is December 11th. That Marcus Taylor's sentence was illegal, but did not commute his sentence because Taylor had missed the deadline to apply for post-conviction relief. So, oops, your window to make a post-conviction relief claim, it's over. It's expired. You're outside your window. Who cares if the thing that you're here for in the first place is legally invalid, is void? So they say, yup, it's incorrect, but too late. And leaving it at that would have meant he had 5 more years to go. That's where he was in May. After rehearing the case last month, the court reversed course, and they ordered Taylor's release. It doesn't stop there. It's not going to stop here, guys. How did we get here? We're going to read more. We're going to see more facts about this. This all stems from Taylor accepting a plea deal in February of 2015 for conspiracy to sell a Schedule III controlled substance. We're going to want to pin this, Schedule III controlled substance, and also plea. Both the trial court and Taylor's plea petition incorrectly listed the maximum sentence as 20 years, according to the appeals court. So I got here and I'm like, oh no. Is this going to be like Moonk-Tunk all over? So we're going to look at the appeals. We're going to see the bullet points laid out of what happened at this plea colloquy. Upon the state's recommendation, a judge sentenced Taylor to 15 years. So judge says, okay, yep, 15 years. State says, give him 15, even though it's not a valid sentence for what he's pleading to. Question of the day, Gwennon. How does that happen? And we're going to get into Reeves' full statement, so we're going to skip this. And then this is a picture. I always feel bad, like we only have a mugshot, and, the point of this article isn't to talk. He's done his time. But that's the picture we have of Marcus Taylor. And this is Governor Reeves. So today we're giving props to Governor Reeves for issuing this executive order. I guess we can jump right to the executive order and then we'll do the appeals. We'll do the Court of Appeals stuff. So apparently this is one of the first times he's commuting a sentence like this. I don't live in Mississippi. I'm not keeping tabs on that, but that's what I caught in another article when trying to find the documents. And we've got this executive order number 1590. So, using Article 5, Section 124 of the Mississippi Constitution of 1890, this relevant part that in all criminal and penal cases, excepting those of treason and impeachment, the governor shall have the power to grant reprieves and pardons. So I have the authority to do this as the governor. Further, the Mississippi Supreme Court has affirmed that the power to pardon includes the power to commute sentences in criminal cases. And whereas on or about July 22nd, 2014, that's what I'm saying, like this is all the way back, Marcus Taylor was indicted by the grand jury of Choctaw County, Mississippi on 3 counts. Count 1 was conspiracy to sell a Schedule III controlled substance. And I'd say that's what he pled to, but we're going to see a problem with that. Count 2, conspiracy to sell a Schedule V controlled substance. And count 3, breaking and entering into the business known as Ackerman Discount Drugs. Further, Taylor was indicted as a nonviolent habitual offender. And whereas in February 2015, Taylor accepted a plea bargain pursuant to which he'd plead guilty to count 1 of the indictment, which was supposed to be conspiracy to sell a Schedule III controlled substance, as a non-violent habitual offender. And the state would recommend a sentence of 15 years in the custody of the Mississippi Department of Corrections. We're going to say MDOC, with counts 2 and 3 of the indictment to be dismissed, in addition to the dismissal of any other pending charges in other counties related to burglary of a pharmacy. So I don't know what this means, but maybe there was other open indictments and this was some type of global resolution. At his plea hearing, Taylor pled guilty to count 1, which is supposed to be conspiracy to sell a Schedule III controlled substance. And the trial judge accepted the recommendation of the state and sentenced Taylor to a term of 15 years as a nonviolent habitual offender in the custody of MDOC. And whereas it's undisputed that is recently confirmed by all 10 members of the Mississippi Court of Appeals at the time of his offense and sentencing, the maximum lawful sentence that could be imposed for the charge of conspiracy to sell a Schedule III controlled substance was 5 years. So thus, as the Court of Appeals stated, it's apparent, I don't know if apparent's the right word, it's apparent that Taylor's 15-year sentence exceeds the 5-year maximum sentence for the crime to which he pled guilty, and thus, such 15-year sentence plainly is illegal. The illegality of Taylor's 15-year sentence was acknowledged by all 10 members of the Mississippi Court of Appeals, and whereas on or about June 1st, 2015, Taylor began serving his sentence for this conspiracy to sell a Schedule III controlled substance, nonviolent habitual offender, we're all going to have that phrase like ingrained in our mind for the rest of the day. Conspiracy to sell Schedule III controlled substance, nonviolent habitual offender. His estimated release date is June 1st, 2030. To date, Taylor has served more than 10 years in the custody of MDOC for an offense that carries a maximum sentence under applicable law of 5. So thus, Taylor's continued service of his illegal sentence in excess of the 5-year statutory maximum, while procedural and substantive issues of Mississippi law are further considered by the Mississippi Court of Appeals, and ultimately the Mississippi Supreme Court, constitutes a miscarriage of justice. And I'm assuming these issues are, the time limit window on when you can make a claim for post-conviction relief. So therefore, I, Tate Reeves, by the authority invested in me as governor by Article 5, Section 124 of the Mississippi Constitution and the laws of the state of Mississippi, do hereby grant Marcus Taylor, they put his inmate number, a commutation of his 15-year sentence to time served. I further direct the Commissioner of MDOC to release Marcus from custody within 5 days of this order. So there we go. This was yesterday that this came down. And it put to rest a saga that Attorney General Lady Fitch wanted to keep going. So how did she want to keep this going? Well, let me jump over to where we talk about this. And here was where I saw the today for the first time since taking office in 2020. This is from Governor Reeves. I've exercised my constitutional authority to grant executive clemency by commuting the sentence imposed on Marcus Taylor, a sentence that was 3 times longer than permitted under Mississippi law. So that was where I heard it was like the first time he was using that. All right, so here we get this little tidbit about Miss Fitch. So last month, Court of Appeals said, although the trial court had jurisdiction over both the person and the subject matter, it did not have the power to enter the particular judgment entered against Marcus Taylor. Therefore, we order the immediate release of Marcus Taylor from his incarceration, as it unlawfully exceeds that which is authorized by law. So this is like the second round with the Court of Appeals, where they're like, hey, you know what? We don't have the subject matter jurisdiction to not release him. Well, after they realize that they shouldn't say first time around, we say the sentence was void, but we can't do anything about it. They have a rehearing, they reverse course, they say, okay, I guess we should release him. Well, we have, according to Marcus Taylor's attorney, Joe Hemleben, he sends a statement into Mississippi Free Press, shout out to them, that's what we're reading right now, thanking Reeves for the decision on the clemency, but notes that before Reeves' order, so before yesterday, up until yesterday, Mississippi Attorney General Lynn Fitch was seeking to challenge the court appeals ruling. Now, when you challenge something like that, that can delay a release. So his attorney goes on to say, while we were successful in the rehearing, turning a 5-5 affirmance into an 8-2 reversal, the Attorney General filed for a rehearing. And I fully expect that the state would not stop there, but seek certiorari in the Mississippi Supreme Court. So this would tie this up. This would tie this up. So, and then we've got the Court of Appeals. Let's get to the Court of Appeals opinion. All right, so before we get into this, shout out to everyone that's popped in. Good morning to everybody, or good afternoon. I'm waiting to see Destin to be enter the chat. I've been waiting, did not see her yesterday, but yesterday was her birthday, so I feel like I should just say it out loud in case she ends up on replay crew. But happy birthday to Destin to be. Hopefully she can pop into the chat. She's usually here. But you know, work gets you busy at the worst times. But we've got, let's see. This is the rehearing. They grant this motion for rehearing. They say the previous opinions of this court are withdrawn and these opinions are substituted in their place. The question this court must decide is whether we are required to deny relief to an incarcerated man suffering under an illegal sentence. The state argues that his relief is barred by the passage of time. In our prior opinions issued May 6, 2025, all 10 members of the court reasoned the sentence was illegal, but we were split evenly on how to address it, ultimately leaving the man's excessive sentence intact. Upon rehearing, we find that Marcus Taylor was erroneously sentenced to a term of years beyond the 5 years authorized by the legislature. In sentencing Taylor to a term of 15 years, 10 beyond the maximum, the trial court exceeded its jurisdiction. When a trial court acts outside the scope of its authority, its actions are void. As over a century of precedent firmly establishes, our judiciary has the inherent power to correct this error, and therefore we reverse and render. So, now we're going to get into the details of this plea and all the things that got us here. And this is why I typically drink cold coffee. I made hot coffee this morning, and I haven't drank any of it, and I can tell it's not hot anymore, but that's why I usually have iced coffee. So 2014, Choctaw County grand jury indicts Taylor on 3 counts. So conspiracy to sell specifically hydrocodone acetaminophen, a Schedule III controlled substance. Second, for conspiracy to sell promethazine with codeine, a Schedule V controlled substance. And last, business burglary for breaking and entering a drugstore to steal drugs. All offenses were alleged to have been committed on or about December 7th, 2013. So one transaction. Taylor was indicted as a nonviolent habitual offender. The case was prosecuted by the Office of the Attorney General. Should I just show her again? Do I have her ready? I have her ready over here. In February 2015, Taylor, represented by counsel, accepted a plea bargain. Under the terms of the plea, he would plead guilty to count 1 as a habitual offender, and the state would recommend a sentence of 15 years. So the state, in considering and negotiating, they're saying, we're going to recommend 15 years for this thing. You would think that they would check the timetables. for the thing that they're going to let stand. Counts 2 and 3 would be dismissed, and, quote, any other pending charges in other counties related to burglary of a pharmacy would be dismissed. And we don't have more information on that. Taylor's plea petition acknowledged that the maximum sentence for count 1, conspiracy to sell a Schedule III controlled substance, was 20 years. So when he's making these considerations, we have you indicted on these 3 counts. On this count alone, you're facing 20 years. Do you want to take a plea deal instead of going to trial? We could cut your time a little bit. Because otherwise you're facing 20. Hanging 20 over his head. This was wrong. And I love, that's it. Nice and succinct. This was wrong. At his plea hearing, Taylor pled guilty to count 1, conspiracy to sell a Schedule III controlled substance. At least 6 times during the hearing, the trial court or the state specifically stated that count 3 involved a Schedule III controlled substance. So I don't know, maybe they were getting mixed up by the Roman numerals. Like count 3, Schedule 3. Maybe we should make Schedule 3 the count 3, just so it just seems consistent. Maybe that's where the mix-up was coming from. But anyway, at least 6 times during the hearing, the trial court or the state specifically stated that count 3 involved the Schedule III controlled substance. So whatever they're reading in court, and I would imagine they're saying like, hey, we're dismissing, we're going to null pros, we're going to nolly count 3. We're going to nolly that count about a Schedule III controlled substance. But meanwhile, he was pleading to count 1, which was the caption of that count would have been this. So which is it? Which is it? The trial court advised Taylor that the maximum sentence for count 1 was 20 years. This was also wrong. As the factual basis for the charge, the prosecutor stated that if the case went to trial, the state would prove that Taylor and 3 accomplices, I thought it was 2, I thought it was 3 total, broke into Ackerman Discount Drugs and stole hydrocodone acetaminophen, which is a Schedule III controlled substance, and conspired to sell the drugs. Taylor agreed that he was guilty of count 1 as described. The prosecutor stated that the state had agreed to dismiss counts 2 and 3 of the indictment and to not pursue or dismiss any other charges or indictments related to drugstore burglaries in other counties, including, but not limited to Carroll, Lincoln, Pike, Yalabasha, and Warren counties. That's kind of fun. That's a fun county name. Taylor agreed to give truthful testimony against any of his co-defendants in any of those counties. The court accepted Taylor's guilty plea and sentenced him to serve 15 years in MDOC's custody as a nonviolent habitual offender. The judgment, which the circuit court signed the same day, did not accurately record Taylor's plea. The judgment correctly stated that Taylor pled guilty to count 1 of the indictment and that counts 2 and 3 were dismissed. So they got one thing right. But the judgment erroneously stated that Taylor had been indicted for 3 counts of business burglary. The judgment did not mention the actual charge to which Taylor pled guilty: conspiracy to sell a Schedule III controlled substance. So this is why I said we had to get through Mario 1, 2, and 3. We're like getting into Mario 2. Because what's going to happen here with the post-conviction relief request with the new attorney, they're going to attack this. And that's why I said, you know what, we've got to do a live stream. We've got to do a live stream because what is going on? So here we are. Consistent with the trial court's pronouncement, the judgment sentenced Taylor to serve 15 years in MDOC custody as a nonviolent habitual offender. 1 year later, Taylor, represented by a new attorney, so it's a year later, they file a motion to reconsider sentencing, in which he claimed that, due to some confusion and miscommunication, Taylor believed that he pleaded guilty to business burglary, which carries a maximum sentence of 7 years. So 1 year into serving the sentence, Taylor and his new attorney file this motion, and they're like, hey, we have this 15, but the cap should be 7. Because this all says stuff about business burglary. And the statutory cap on that, maximum 7 years. So what are we doing? So Taylor asked the court to resentence him consistent with the maximum sentence for business burglary. In response, The state filed a motion to amend the judgment to show that Taylor pled guilty to conspiracy to sell a Schedule III controlled substance. So the state says, oh, no, you're right. You're sort of right, but instead of changing it to match the judgment, let's amend the judgment to instead show that he pled guilty to the Schedule III controlled substance conspiracy. The state characterized the original judgment's indication that Taylor pled guilty to a burglary as a scrivener's error. In March 2016, the trial court, and there's a footnote we'll get to, entered a corrected judgment recognizing that the original judgment should have stated that Taylor pled guilty to conspiracy to sell a Schedule III controlled substance, not business burglary. The corrected judgment made no change to Taylor's sentence. So they get to the castle. And it's like the little Mario thing where they're like, oh, I'm sorry, but Peach is in another castle. And you got to do it again. So you like get there, but then you don't get there. They make no change. They have the opportunity to say, hey, you know what? Since we have it top of mind right now that sentencing max was at issue, maybe we should just double check. Okay, look, I think we need to redefine scrivener's error. Scrivener's error is supposed to be something that's like harmless mistake. It was, poorly transcribed. It wasn't written correctly, but we know what was supposed to be said. But in its use case, it seems like scrivener's error is more and more used of, we made a big oopsie, but let's just say it was a scrivener's error. So, also, I see some balloons in the chat, or confettis. So, yep, okay, so Peter Steele's saying, destined to be, happy birthday for yesterday. So, destined to be must be in the building. Throw some balloons. Let's wish destined to be a good one. And since we didn't get to hang out with you yesterday, you get to celebrate all week. So, hope you are having an awesome one. Great to see you. Always great to see you. And destined to be says, I had a great day. That's always good to hear. Everybody deserves a great birthday. So, we've got also a wish from FFS and from O'Bailey's and from Martina Nem. All right, so back to the scrivener's error. So they don't change the, I was going to the footnote, right? Yeah. So Judge Clarence E. Morgan III, another third, lots of Roman numerals, accepted Taylor's plea, sentenced Taylor, and entered the original judgment in the case. Judge Morgan retired in December 2015, and Judge Joseph H. Loper Jr. presided over all subsequent proceedings in the case. All right, and then that footnote was where? Where did we leave? Okay. So 2 days later, the trial court denied Taylor's motion to reconsider the sentencing. The trial court stated that it had reviewed Taylor's plea petition and the transcript of the hearing and found that it was clear, and they put clear in quotes, that Taylor was fully aware that he was pleading guilty to conspiracy to sell, oh my god, a Schedule II controlled substance. Chat. So we fix it and then we break it again. We fix it and we break it again. This is like when you get hurt in Mario and your power-up starts dropping down from the box, your backup power-up, because like you had the little fireball hat, you lose that because you get hit, but you've got another fire flower and it's dripping down, but it just falls and you miss it and you don't get it. We had the chance to catch it and we just, nope. Schedule II controlled substance, not 3. And that the sentence imposed was consistent with Taylor's plea bargain and plea petition. Okay, but is it consistent with the indictment? We should just make that a practice. Like, the first question we should always ask, is this consistent with the indictment? And is the indictment valid? Properly charged? The trial court acknowledged that the original judgment contained a clerical error in indicating that Taylor pled guilty to business burglary, when in fact he pled guilty to conspiracy to distribute a Schedule II controlled substance. And they're noting here, the Court of Appeals, that they're adding this emphasis on the 2 Roman numeral. This order's 2 references to a Schedule II controlled substance are the only such references to a Schedule II controlled substance in the entire record. Oh my gosh. Chat. And again, even if all of this wasn't happening, like one big mess, I still think it's problematic during a plea hearing to not have the upper limit accurate. When you're in negotiations and you're misleading somebody on what they would face, even if you're presenting only certain terms to the court, like, hey, we're going to null pros, count 2 and 3, and this plea is only going to be for count 1, and that carries a maximum of 20, and we're going to recommend 15. All of your negotiations were based on all of that information together. How can you say that Taylor wouldn't have just taken this to trial if he thought the timetables were different, if he had a accurate picture of what the timetables really were? How can you say his negotiations wouldn't have gone differently if he knew he was only facing 5? But telling someone they're facing 20 plus whatever the other 2 would have carried, and any relevant fines, well, no fines, we'll just recommend 15 instead of 20. You won't have to worry about the other 2, but sign this line and promise that you'll testify against the other 3. Well, state gets what they want. They get to secure the testimony they need for 3 other prosecutions. Or they secure the threat that, hey, if you guys also don't take a plea, the other 3, this guy's going to testify against you. It's worse for you now. So let's make this easy. Let's just give us the conviction. Just sign off on it. Like, the process there should be integrity through the whole part of the process. Like, I don't think we should really blame that on a Scrivener's error. We should double check what the timetables are before we're entering and telling somebody what they're facing, but we're willing to negotiate. That's just me. That's just what I think. So let's see. Now we're in the seeking post-conviction relief phase. So 7 years passed. In March 2023, Taylor, again represented by his original attorney, filed a rather unusual PCR motion. So PCR is post-conviction relief. Although it was styled as a PCR motion and cited the Uniform Post-Conviction Collateral Relief Act, the motion did not articulate any cognizable ground for relief under the Act. Rather, Taylor argued that he had been rehabilitated during his term of incarceration, that his prior criminal history was attributable to his youth, peer pressure, and a lack of education, that 2 of his co-defendants had already been released from custody, and that his children and elderly parents needed his support. For all these reasons, Taylor asked the court to resentence him with parole eligibility as a non-habitual offender under the Act, the Post-Conviction Relief Act. The trial court denied Taylor's motion. The court recounted the case's procedural history, and that in 2015, Taylor pled guilty to conspiracy to sell a Schedule III substance and was sentenced to the 15 years, that the original judgment contained the Scrivener's error, and that the court in 2016 entered the corrected judgment, imposing the same sentence for the true crime of conspiracy to sell a Schedule III controlled substance. The trial court then held that Taylor's motion was barred by the statute of limitations, that none of the statutory exceptions to the statute of limitations applied, and that the court had no authority to modify Taylor's sentence. So, proceedings on appeal. Taylor, they said his appeal was timely. After briefing was completed, and although Taylor did not raise the issue, this court directed the parties to provide supplemental briefing. In that order signed by presiding Judge Wilson, it was pointed out that despite the 15-year sentence Taylor received, so this is coming from the Court of Appeals judge. This is where we're getting it realized. The maximum prison sentence for the conspiracy to which Taylor pled guilty is only 5 years. Accordingly, we requested briefing on 2 points. So the Court of Appeals is like, hey, we need more info. Is the maximum prison sentence for Taylor's offense 5 years? If so, is Taylor's 15-year prison sentence illegal? So it wasn't even an attorney. It wasn't the state realizing the mistake. It wasn't any of the trial court judges. It was Taylor filing an appeal on this decision that was filed under a PCR act, but was really just about like asking for a reduction in time. That they just happened to notice this. The second point they want briefing on is Is Taylor's PCR motion nonetheless barred by the 3-year statute of limitations of the Uniform Post-Conviction Collateral Relief Act? So I think this was we saw a reference of, hey, we're going to commute the sentence while these other issues play out otherwise. This court issued an evenly divided opinion on May 6, 2025, ultimately resulting in affirming the trial court's denial of Taylor's motion for post-conviction relief. The lead opinion explained that while it's apparent that Taylor's 15-year sentence exceeds a 5-year maximum sentence for the crime to which he pled guilty, he filed his PCR motion 8 years after his judgment was entered, or 5 years too late. As a result, the lead opinion concluded that the circuit court correctly found that Taylor's PCR motion is barred by the statute of limitations, and he was entitled to no relief. Taylor timely filed a motion for rehearing. 2 days later, the Mississippi Office of Capital Post-Conviction Counsel sought leave to file an amicus curiae brief in support of Taylor's motion for rehearing, which was granted. Okay, so shout out to the Mississippi Office of Post-Conviction Counsel. And then here they discuss it. They say that courts may only act when they have the power to do so. So do we have jurisdiction? Or does the trial court have jurisdiction? So I kind of see why this played out this way now that we made it this far, at least from Court of Appeals Stage 1 to Court of Appeals Stage 2. Unfortunately, it doesn't seem like we would have gotten there had Taylor decided, I'm not going to try for a rehearing. It seems like we only got here because he said, I want a rehearing. But now we're going to look at jurisdiction. And because we're going to find, they're going to ultimately find that no trial court can sentence somebody to something that's outside the statutory, what's allowable by the statute, right? So they're beyond the threshold. So I'm sure we can summarize all of that. Let's see. Case law. All right, so then what happens with post-conviction habeas corpus? So you're holding me and you don't have the right to hold me. What happens? They're saying here with this header, post-conviction habeas corpus is absorbed into the Post-Conviction Relief Act. That's why I think we have some issues they've got to iron out after this. Our Supreme Court's decision in Burden expressly centered on whether habeas corpus was available to a defendant after his conviction. The court concluded it was. The Constitution of 1890 declared that the privilege of the writ of habeas corpus shall not be suspended, unless when in the case of rebellion or invasion, the public safety may require it, nor ever without the authority of the legislature. A habeas corpus proceeding has but one purpose, and that is to set at liberty persons illegally held. The purpose of the writ of habeas corpus is to give a person restrained of his liberty an immediate hearing so that it can be determined whether that person is being deprived of constitutional rights, such as the right to due process of law. In 1984, the legislature attempted to corral the variety of common law methods a prisoner might use to attack a conviction or sentence by adopting the PCR Act. Oh, this is a great characterization. So when I was reading the title of this act, doesn't something like Post-Conviction Relief Act seem like it'd be something that's helpful and, we want to make post-conviction relief more available and people can be more informed and have access to resources and we know what to do when something goes wrong that would warrant post-conviction relief? Well, apparently, according to this characterization by the Court of Appeals Act, if we reread this, this opinion says that the legislature attempted to corral the variety of common law methods a prisoner might use to attack a conviction or sentence by adopting the PCR Act. So it seems like, at least in the view of this Court of Appeals, whoever wrote this opinion, that the Post-Conviction Relief Act was meant to restrain and reduce the avenues available, which had as its express purpose to revise, streamline, and clarify the rules and statutes pertaining to post-conviction collateral relief law and procedures, to resolve any conflicts therein, and to provide the courts of the state with an exclusive and uniform procedure for the collateral review of convictions and sentences. So if it's not in this paper, it's not going to be available to you to use as an avenue of recourse. That's what they did with this act. In doing so, the act purported to abolish the common law writs relating to post-conviction collateral relief, including by way of illustration but not limitation, error coram nobis, error coram vobis. What's coram vobis? So error coram nobis, we've learned, thanks to you guys in the chat and covering the Zachary Adams post-conviction relief hearings. It's a way for the trial court to correct mistakes that happened within the trial court. Let's see what coram vobis is. The error coram vobis is a legal term that refers to a writ of error issued by an appellate court to correct errors of fact made by a trial court. Okay, so there we go. It's we typically will say, hey, appeals courts try not to change and touch the factual determinations of the trial court. But with a coram vobis, appeals courts will challenge that fact finding. And post-conviction habeas corpus, as well as statutory post-conviction habeas corpus. Not long after the legislature noted this abolishment, the Supreme Court ruled in Walker it was ineffective as to habeas corpus. A defendant was convicted of the possession of cocaine and sought bail pending appeal, which was denied. He then sought habeas corpus relief, not in the trial court, but with the Supreme Court itself. The court ordered the trial court to have a full hearing on the merits of the request for bail. The Attorney General protested and asked the court to rehear its decision. The Attorney General's core argument, as in the case before us, is that the only avenue for relief was PCR, not habeas. That pesky habeas. The Attorney General argued that any suggestion that the matter is a habeas corpus action which should be heard in the jurisdiction of confinement is erroneous in the view of Mississippi's Uniform Post-Conviction Collateral Relief Act. So there you go. Yep. I would say proof in the pudding that that act was meant to restrict the avenues of relief available. So any relief beyond that must be sought pursuant to the Post-Conviction Collateral Relief Act and must further be sought in the trial court of conviction. And I've really got to hammer home, sometimes the way things are named, the way things are titled, things can sound good. And then they don't do what you would expect in the name for them to do. The Supreme Court rejects this argument. It first determined that the Post-Conviction Collateral Relief Act is inapplicable in this situation. Generally speaking, purely collateral post-conviction remedies attacking a judgment of conviction or sentence should be sought under, generally speaking, be sought under authority of the Post-Conviction Collateral Relief Act, since that act, in the pure post-conviction collateral relief sense, is arguably post-conviction habeas corpus renamed. But arguments over nomenclature should be avoided so long as the act affords the relief formerly available by habeas corpus in this limited context. So since Walker was not attacking his conviction in the strict sense of post-conviction collateral proceedings, the court held that it could review the habeas request. So they said, you're not shrinking the lines that we need to color within. We're still coloring within the lines. Sorry if you're mad about it. 6 years after Walker in 1996, the court reiterated that the state is incorrect in its argument. There's a lot of, this has been a good time of the state is wrong. The state is wrong again. The state is incorrect in its argument that the writ of habeas corpus was abolished by the Post-Conviction Collateral Relief Act. So we're speaking 2002 already. The state was already put on notice that they can't just, post-conviction relief statute of limitations has run up, the window's closed, when it's a habeas issue. They know this. This has been established since 2002. But here we are. And again, Mario's a great example because Mario's like a million decades old. The Supreme Court has found, this is Hill v. State. There's always a Hill v. State. I feel like every state has case law with the caption Hill v. State. The Supreme Court has found that the writ of habeas corpus remains available even though the Post-Conviction Relief Act explicitly establishes the procedure to replace habeas corpus in most situations. Seeking to harmonize this jurisprudence and the PCR Act, a former member of our court opined that it is more accurate to say that the procedures for the writ of habeas corpus in post-conviction matters have been established by these statutes, but the writ itself remains alive. For as the Supreme Court has concluded, the overriding intent and purpose of the Post-Conviction Relief Act is simply to guide and assist the judiciary in its duty to provide an orderly means of administering the post-conviction claims of a growing prison population. Well, the state wants to do the opposite, it seems. It wants to keep those heads in beds, put more heads in beds, keep them there longer. So the judiciary, again, seems much at odds with state attorney and the legislature here. So that's Sykes v. State. That's back in 2000. The Supreme Court returns to legislative intent behind the act. For many years, these distinctions were mostly academic. The PCR Act expressly allows for a 3-year statute of limitations period from the date of conviction by way of a guilty plea or after a direct appeal. However, the Supreme Court implemented its own judicially crafted exception to the time bar, which allowed a petitioner to file an out-of-time challenge if the claim involved the individual's fundamental rights. Well, do you think being sentenced and held, you're still... So the incarceration aspect is important here, right? You know, that gets us to the habeas realm. So this sentence kept him unlawfully incarcerated, without a doubt, because his sentence was legally invalid. So once he hit that 5-year window, habeas issue. That's a fundamental right issue. Accordingly, there was little discussion after the creation of the fundamental rights exception on what method could be used to attack an excessive or illegal sentence, as issues involving violations of fundamental rights could be raised at any time. There you go. There you go. This is where the state's going to be. Yeah, we want to frame it how we want to frame it. We want to put the blinders on. We want to put the blinders on. I see Chris Airley's recognize your picture. Good to see you, Christy. Hey, Annie from Great Britain. Good to see you from the UK. Hey, Frank. Good to see you. Good to see you. We're getting through these. Like, it's kind of shocking. I feel like they're going through this procedure not just because, hey, we're going to make a record of the case law we're relying on, but I feel like there's a little bit of, how do we make this any more clear? That a habeas claim, something that would go to someone's fundamental rights, you can't just say, oh, that's not an avenue allowable by the PCR Act. Like, how can we make this any clearer? So they say, however, in the Howell decision, the Supreme Court decreed that it would return to a faithful interpretation of the statute in accord with the express legislative intent, in turn abolishing the fundamental rights exception. Yet within Howell is an important caveat that recognizes that there are other arguments or doctrines that preclude an absolute application of the time bar. So paragraph 12 of the Howell opinion, the majority of the court acknowledged that other arguments may be used to attack the constitutionality of the statutory bars, either as applied to particular cases or on their face. The court further recognized that in specific cases, other arguments or doctrines, like equitable tolling, might be available to afford relief from the statute of limitations. Indeed, it was this language in paragraph 12 that the court used as a fulcrum for reversing and rendering a judgment decided later that same year. So this is 2023. A PCR petition claimed to be illegally held, contending his indictment for possession of ethylone was defective and did not charge a crime. So, being held pre-trial for a defective indictment, at least I assume is this pre-trial or... No, this is post-conviction because the post-conviction petitioner. Dang. So... there you are. We have a flawed indictment. Maybe they didn't realize it until after trial, after pleading, however we got to this disposition and sentence. But he urged the Supreme Court to find that actual innocence claims survive Howell and constitute an exception to the statutory time bar under the Post-Conviction Relief Act. The facts were unique, as both the Court of Appeals in a previous opinion and the Supreme Court agreed that Hathorne's indictment had not charged him with a crime as defined by this legislature. So now we have a indictment that, even if we accept the indictment as alleged, that there is still no violation of a law. There is no criminal act because it wasn't charged properly. It's feeling like Fulton in here. In reviewing Howell, the Supreme Court pointed out that paragraph 12 had left open the door for other challenges that are not substantive in nature. Without elaboration, the court determined that it would then turn to the facts of this case utilizing that approach. Ultimately, the court decreed that Hathorne's defective indictment could not be waived through inaction or inaction, since it was a nullity and may be objected to at any time. Here we go. This is like the common sense argument finally being spelled out. It doesn't really matter if you want to say, well, there's a time window, well, there's a statute of limitations, because the thing that we're even considering the statute of limitations for, had it been valid, isn't actually valid. Before we even get there, we don't even have something valid to be arguing about. So it's a nullity and may be objected to at any time. And the same would go for an invalid sentence. So crucially, the court held that to hold otherwise in this case would preclude relief from a person who we have determined was never charged with a crime, serving 20 years in prison day for day. Granting relief in this extraordinary case is the only just outcome. To keep Hathorne in prison under no legal requirement would certainly constitute cruel or unusual punishment and an excessive fine, which is expressly prohibited under our Constitution. So accordingly, that court reversed and rendered the conviction. All right, so now we're going to get after all that analysis. Applying that to this case we're talking about today, Marcus Taylor. The trial court exceeded its authority in sentencing Taylor. So like Hathorne, this appeal presents us with a unique situation. While 3 opinions comprise our first review of this matter, all 3 opinions, the lead, a separate concurrence, and a dissent, they all agreed that Marcus Taylor was serving a sentence in excess of what the law required. So that was that initial 5-5 split, right? Yeah, I think the first one was 5-5. But that wasn't like 5 people saying, we think it was valid, and another 5 saying, we don't think it was valid. All of them said, hey, this is not authorized. This sentence is not authorized. But the disagreement rested on whether they could do anything about it. Taylor pled guilty to the crime of conspiracy to sell a Schedule III drug, which carries a maximum penalty of 5 years of incarceration. Nonetheless, he was sentenced to and is still currently incarcerated under a sentence of 20 years. Again, the commutation from the governor came down yesterday, so after this opinion was published. There's a footnote here that says MDOC lists Taylor's release date as June 2030. It also lists his offense as burglary. In Hathorne, a unanimous Supreme Court declared it would not preclude relief from a person who is incarcerated under no legal requirement, as to do so would constitute cruel or unusual punishment, contrary to our Constitution. As that document guarantees, cruel or unusual punishment shall not be inflicted, nor excessive fines be imposed. Over a century ago, long, long ago, our Supreme Court made clear that when a trial court acts in excess of its jurisdiction, it creates a void judgment. So they're gonna cite all of this stuff. I think it's hilarious that the caption name is Burden. That's a great name for any case law, Burden. And as a matter of law, it is without debate that confining Marcus Taylor to a term of years in custody beyond that authorized by statute is an illegal sentence. This is an offense to our Constitution that cannot stand. For our citizens have a fundamental right to be free from an illegal sentence. They're citing Young v. State and Snead v. State that the right to be free from an illegal sentence has been found to be fundamental. So, same thing. In accord with Howell and Hathorne, we recognize in this extraordinary case that the judiciary must act to correct a manifest injustice. In accord with Burden and McHenry, we conclude that the trial court was without authority to impose upon Taylor a sentence exceeding that authorized by the legislature. The trial court, in error, imposed an excessive sentence on Taylor of 10 years beyond the 5-year maximum for the crime of which he pled guilty. In doing so, the trial court exceeded its jurisdiction, and therefore the excessive sentence is utterly void. Utterly void. As Judge Lawrence solemnly declared regarding our original decision, Make no mistake about it. Taylor sits in jail, illegally held, because a judicially crafted order incorrectly provided for a 15-year term when 5 years was a statutorily mandated maximum sentence. The judicial branch created the illegal order, and this court should have the inherent authority to correct that order. Courts lacking the ability to correct illegal and erroneous orders stands contrary to the foundational and fundamental aspect of what the courts do and stand for. It should not require a grace from the legislature for the judiciary to fix a judiciary problem. So this is why we still have that ongoing, they've got to sort out their issues. Because that's why we needed Governor Reeves. We needed that commutation. So conclusion, although the trial court had jurisdiction over both the person and the subject matter, it did not have the power, so that's outside of their authority, to enter the particular judgment entered against Marcus Taylor. Therefore, we order the immediate release of Marcus Taylor from his incarceration, as it unlawfully exceeds that which is authorized by law. Accordingly, we reverse the order denying post-conviction collateral relief. We render void the part of the corrected judgment sentencing Taylor to more than 5 years in custody. Reversed and rendered, and we have a dissenting opinion. Let's see. So, we have Wilson. We have one person concurs in part and dissents in part without separate written opinion, and then Wilson dissents with separate written opinion, joined by Empfinger. So this is where we get that 2 split off, but it's only in part. So we'll take a quick look at this. But remember, right after this rehearing, they reverse. The reason we need the commutation for Marcus Taylor to finally be released is because the state, the Attorney General, Miss Fitch, says, oh, I'm appealing this. This isn't right. That's not what the act says. You don't have the authority. It doesn't matter if the sentence was void. The statute of limitations ran out. So she took issue. She was appealing this decision. And again, speculation, but I don't think it was misguided speculation. Taylor's attorney, Joe Hemblin, says, hey, probably wasn't going to stop with just challenging this Court of Appeals ruling. I would fully expect that the state would take it up to the Supreme Court, keep it going. And through that pendency, unless bond was granted, which I'm sure the state would fight as well, because why not? It would have been a further delay in the release for Taylor. So that's the Court of Appeals. That's the majority opinion. We do have this dissent here, so let's take a quick look at that. We've got, let's see, Taylor's 15-year sentence exceeds the 5-year maximum. So we concur, not valid. However, we're gonna write our thoughts on the Post-Conviction Relief Act. This Post-Conviction Relief Act provides that a motion for PCR relief must be filed within 3 years after the entry of judgment of convictions entered on a guilty plea. Taylor filed his PCR motion 8 years after his judgment was entered. The PCR statute of limitations includes certain statutory exceptions, but none apply here. We have a footnote. Therefore, PCR bars Taylor's claims. So we have this opinion plus one justice enjoining. So 2 are saying it's too late. This footnote says, and it's a quote, that cases in which the petitioner claims that his sentence has expired are accepted from the statute of limitations. That's from the Mississippi Code Annex 99-39-52B. However, the Mississippi Supreme Court has held that this exception does not apply to a case, such as this one, in which the petitioner argues that his actual sentence is illegal, and the illegal sentence he should have received would have expired. The court stated, this is obviously not a claim that the sentence has expired. It is a claim that the sentence is somehow incorrect or illegal. This claim is not accepted from the time bar by virtue of the statute. Likewise, Taylor's sentence clearly has not expired. Rather, he claims his unexpired sentence is illegal. Okay, so back up here. Prior to Howell, we would have addressed the merits of Taylor's claim under the so-called fundamental rights exception of the statute of limitations. However, Howell expressly overruled any ellipses case in which the Mississippi Supreme Court had held that the courts of Mississippi can apply the judicially crafted fundamental rights exception to constitutional, substantive enactments of the legislature, such as PCR's 3-year statute of limitations. Moreover, Howell specifically held that a claim alleging an illegal sentence is not accepted from the PCRA Act statute of limitations. Subsequently, in Haythorne v. State, the Supreme Court reiterated that the Act's statute of limitations precludes relief on a claim alleging an illegal sentence, even if the claim is meritorious. We've got a footnote. The majority's reliance on Haythorne is misplaced for two significant reasons. First, Hathorne, I keep saying it different, specifically emphasized that Hathorne's claim was not barred by the statute of limitations, stating, first and perhaps most weighty, this is Hathorne's first PCR motion, and it was timely filed. Second, as noted in the text, Hathorne specifically reaffirmed that the Act statute of limitations bars even meritorious claims alleging an illegal sentence. Where were we? Therefore, under both Howell and Hathorne, the Act's statute of limitations bars Taylor's claims. So there we go. They're going to contest here. They say the majority argues that we may consider the merits of Taylor's claim because the trial court lacked jurisdiction to impose a sentence that excluded the statutory maximum. Notably, claims that the trial court was without jurisdiction to impose sentence and that the sentence exceeds the maximum authorized by law are cognizable grounds for relief under the Act. However, just as notably, in the very same section of the Act, the legislature did not include such claims in the list of exceptions from the Act statute of limitations. Thus, the legislature expressly authorized relief on such grounds, but also made clear that such claims are subject to the 3-year statute of limitations. So this is an argument that because there wasn't, it wasn't expressly included as an exception to the statute of limitations, that the statute of limitations must necessarily apply. And I would love to see a counter order, because I guarantee you there's going to be some, they didn't need to include it because it falls under, a restriction of fundamental rights. So, but yeah, that's not how, we don't get back and forths. The law has not changed since we previously affirmed the denial of the PCR motion, and the statute of limitations still bars Taylor's claims. Therefore, I would deny the motion for rehearing, and I respectfully dissent. So we have Empfinger, I think this guy was Wilson, or maybe a lady, and we have the Attorney General that are like, no, keep the sentence in place, keep him for 15 years for his crime that carries a max penalty of 5 years. Who cares if it's a mistake? Who cares? That's what it is, and that's how it shall be. And, in response to all of that, we just have this shutting it all down. So Governor Reeves exercises, he says for the first time, he commutes Taylor's sentence, and Taylor, if he's not released already, I think there's like four days left, because he has to be released within 5 days of this order. So clock is running. If he's not released already, he's got 4 days, and he needs to be released. So there we go, guys. That is the... That's how I woke up. That's how I woke up. And I read a little story. It was like a paragraph long, and I was already like, this is stupid. And here we are. This is how it goes. So thank you guys for going down this ride with me. I love stuff like this. I hate stuff like this. We've got Mr. Big Play Bray saying, after seeing Fulton County plea agreement shenanigans, I now believe all plea agreements are crooked. Like, you gotta check it like a million times. And it just... How can a layperson knowingly and voluntarily understand what they're saying? Yes, I'm agreeing to this, I understand, when attorneys on both sides of the aisle don't understand and judiciaries don't understand? How can a layperson, how can you say, well, they agreed to it, they knew what they were signing? Did they really, if what they were signing was something that isn't valid in the first place? But yeah. And yes, Jillian, the state is mad it was made right. The state is mad it was made right. Sheriff Chuck says, what is not a burden is to hit that like button. That's right, you guys, hit that like button. It does the YouTube things or whatever that is. I appreciate it. It makes me feel good. I think it helps the algorithm. So if you want more people to get in here and go, why do things like this happen? Hit that like button. Make them suffer with us. Geez Louise is here, but a little bit late. That's okay, Geez Louise. You are very busy, always researching something. Yeah, I didn't even have time to put a hat on this morning. Usually, like, I'll run to the store in the morning at like 7 o'clock, get anything I need to make dinner. That way I don't have to do it at 5 o'clock when the roads suck and traffic sucks. I got right here because I was mad. So, yeah, Gwen and Garnett, I don't know. How can there be a fundamental rights exception? They're fundamental and rights. Listen, you put lawyers in a room, somebody's going to argue something somehow, some way. Hey, Candace, good to see you. Sheriff Chuck says as long as there are no consequences for the state, they will continue to do harm to the citizens. It doesn't cost them anything to fight these things. So, yeah. Jillian says, yeah, I mean, even corrupt judges just retire, and that's that. Yeah, Affy says, good morning, Kat. It's too early for this, despite being awake for 2 hours. Exactly in the same boat. I feel the exact same way. Oh, man. Shayna says, oh my gosh, just the name of this live has me mad. I'm sorry, Shayna. Good to see you. Good to see you. Big Dog Fluff says a 2-cup kind of story. I'm gonna go, like, put some ice in this. Fix it up the way I normally would. My mug doesn't even have, like, residual warmth anymore. This is a mug my mom sent me a long time ago, by the way. It says, a daughter makes the day brighter and the heart warmer. So, we've got, Jillian says that's scary. I myself have been tricked with signing government stuff, and that's with not having facing any kind of penalty. Like, things get complicated, and they're full of jargon, and read things quickly. You trust. Why would somebody put something misleading in front of me? But you never know. Yeah, even, I would hope that Florida would help me keep my coffee warmer later, but, we have a cold streak of like 70 degrees right now, so hot coffee not staying hot too long. Let's see. Okay, I didn't know this about Koberger, which is surprising. I usually at least see stuff on on my X timeline. So Koberger blew up this week due to the crime being heard on a camera that got FOIA'd, and it didn't happen at 4 a.m. Uh-oh. Well, that's interesting. So putting a note in that's definitely interesting. I'll get off of this and go down another rabbit hole. Guys, I don't know who's live right now. Maybe Dolly Talk. Is it too early for him? I think he usually goes live at 9. We can head over there, watch some court roulette. I think that's a lot more low intensity than sending us over to watch like a murder trial or something. Let's see. We've got... And I'm trying to do some Zachary Adams post-conviction relief stuff. So if you have not been following the post-conviction relief stuff for Zachary Adams, but enjoy like post-conviction stuff, we are looking at coram nobis stuff, letting the trial court fix its own errors. Jury at trial didn't get to see evidence that, quite frankly, I think, without a doubt, alibis Zachary Adams and his co-defendants, at least Sheen and Dylan. It's a hot mess. I'm not going to go down my rants because I could be here for another 2 hours going down those rants. But you could join us, tune in, and we'll be going over different issues. I think we might look at some pretrial hearings today because I've been talking a lot, so I don't want to read a bunch of motions after reading a bunch of motions. But we'll be looking at motions or pretrial hearings to disqualify the judge. I think an issue with the prosecutor before trial, and to bring on an additional attorney. This is a death penalty case. Zachary Adams' defense team wanted to bring on another attorney. That was denied. Judge said no, but there was hearings for it. So I think we might watch those later today, probably in about 2 hours, starting that up. So keep that pinned. I'll schedule it a little bit in advance, that way you see it. But until then, we'll watch something a bit more, a bit less intense, like Courtroom Roulette with Dolly. See. All right, he is live, so we'll take a trip over there. Also pinned at the top of this chat if you're watching live, and in the bottom of the description if you're on replay crew. Happily Angry Lawyer posted a video last night It says part 8 of the ways Fulton County lied and got the whole Munk-Tunk situation, Antonio Sledge situation wrong. So if you miss YSL trial content, if you just like cases where there's legally void sentences and terms of pleas being misrepresented, and a lot of funny business that I don't think can be described as Scrivener's errors. Happily Angry Lawyer has an 8-part series on what Munk-Tunk is going through because of Fulton County over in Georgia. So check that out, pinned up and pinned in the description. Definitely worth it. It's like a 20-minute video. You can get right through it. And Happily Angry Lawyer is always a good time. Other than that, you guys, see you next time. See you next time.